Good afternoon, this is Sean Golding with Golding & Golding, here to discuss a few of the pros and cons of submitting to the IRS Streamlined Offshore Filing Procedures. When an individual trust or estate is non-willful and considering submitting to the IRS for previously unreported offshore or foreign accounts, assets, income, or investments, they have two options under the Streamlined program. They can submit to either the Streamlined Foreign Offshore Procedure, which is for non-U.S. residents, Streamlined Domestic Offshore Procedures, which is for U.S. residents. The programs have been very popular. The word around the tax street is that they're going to be discontinuing the program soon. So why don't we talk about some of the pros and cons in case you're considering the program in lieu of either reasonable cause or possibly the traditional voluntary disclosure program. A quick side note on that, the IRS did close OVDP, which is the Offshore Voluntary Disclosure Program. But in March 2019, they also significantly expanded the traditional voluntary disclosure program to include much more specifics regarding offshore reporting. Why don't we talk about three of the pros for the IRS Streamlined procedure? First, it's less paperwork. Under voluntary disclosure, there's a significant amount of additional paperwork that's needed. Taxpayers have to extend statutes and things like that, which is important if you're doing the voluntary disclosure program, but if you're non-willful, it could be considered onerous. So first, there's less paperwork. Second, the penalty is reduced. Under the Streamlined Domestic Offshore Procedures, there is a single 5% penalty on the highest year's unreported balance at the end of the year. So for most people, their year-end balance is significantly less than it would be during the year. In addition, all that 5% penalty is in lieu of all those horrible penalties you've read about online. If you're lucky and you qualify for the Streamlined Foreign Offshore Procedures, it's even better because you get a complete penalty waiver. Final is you're not at a high audit risk. So one common question we get is, if you do the Streamlined program, do you increase your chance of audit? Not necessarily, because you're in compliance now. So for the IRS to come back and audit you, they're going to have to find more information and somehow prove that either you knowingly didn't include certain assets or accounts in the submission or that you're willful. It's not impossible, but it's still difficult for the IRS to do that. You can still get audited. There's no audit protection by doing Streamlined, but it doesn't necessarily increase your chance of audit risk. If you're ordinarily at a high audit risk, you'd still be at 1. If you're ordinarily at a lower audit risk, you'd probably still stay in a lower audit risk category. There are some cons or negatives of doing the Streamlined procedure. Kind of expanding on that last bullet point, there is no protection from future audit. Under the previous OVDP, 99.9% of the time there would be no audit unless the taxpayer proactively opted out, or if the IRS was making maybe an information document request, requesting documents regarding foreign tax credits or whatnot, which is kind of an audit, but technically not really. One major con is that there is no bright line test for non-willfulness. So when you're doing the certification statement on the Streamlined, you have to sign under penalty of perjury that you're non-willful. The IRS doesn't provide a bright line test. There's no bright line rule. So you have to just kind of go with the totality of the circumstance analysis. Complicating it even further is that willful does not mean intent. So willful can mean reckless disregard, which is without intent per se, or willful blindness, which is without actual knowledge. So you have to be careful that certification statement is tight, concise, and accurate because it's being signed under penalty of perjury. There is a potential risk for audit of prior year returns beyond the Streamlined. So to give you an example, when you do voluntary disclosure, you're submitting 6 years of amended tax returns or original returns. Same with OVDP back in the day. Most statutes go back 6 years. Unless it's civil fraud, then it goes on forever. But absent that specific situation, 3 to 6 years. When you're doing the Streamlined submission, it's generally 3 years of amended or original returns, 6 years of FBARs. So the 3 prior tax years could possibly be at issue So for some individuals who just want to get it all done, they're not really sure if they qualify as non-willful, or maybe they're on the border and they're very risk averse, they may still consider doing the traditional voluntary disclosure program. That was introduction to some of the pros and cons of the streamlined offshore filing procedures. We have lots of free information available on our main website, goldinglawyers.com. We also have a sister website, IRSStreamlinedProcedures.com, devoted exclusively to the streamlined procedures. I appreciate you taking the time to listen to me today. Have a great rest of the day.